Good evening. This is Tim Markle. I'm director of the Southern Regional Center for Children and Youth with Special Healthcare Needs. We're based out of Waysman Center in Madison, but we cover 14 counties in southern and southwest Wisconsin. And it's southwest Wisconsin that we are giving a shout out tonight. This is a follow-up to a most awesome, I feel like Bill Ted or something, most awesome conference that there ever was so far in southwest, yes, in southwest Wisconsin, the Harnessing Abilities Conference, all about transition. My son Hunter is with me tonight, and we got to present at that conference. We're really excited about that. We're excited to be bringing you the first and what we hope will be a series of follow-up rounding up resources based on the transition ideas that we talked about at the Harnessing Ability conferences and some of the ideas that Temple Grandin touched on, as well as some of the other panelists. Rose Cutting, who was the driving force behind the conference, is here tonight, and we welcome Tami Jackson from the Wisconsin Board of People with Developmental Disabilities. She is their policy analyst, specialist, and all around really cool person. So we're really excited that she is here tonight. I'm going to step away and turn this over to Hunter. You could just do me a couple favors. Put your name and your county so that we have an attendance in the chat box. And we will be recording this. We will be getting the PowerPoint, and we will get that out to everybody who has registered. So thank you. And Tami, I turn this over to you, Hunter and Rose.
Okay, well, I'm going to navigate to my presentation. So Rose, if you have anything you want to say about your organization, please go ahead and take it away.
Of course, my unmute button. No, I'm just super excited to go ahead and hear your continuation in the further abilities of us to gain resources out here. So I'm going to let you have, and then I'll remind everybody when the next one is at the end of this presentation, okay?
Okay, so can everybody see my screen so far? Yes, Hunter says yes. Okay, so I'm going to talk a little about tonight, mostly about supported decision making, but also about some of the other things that you may be hearing about during transition time. Oftentimes, young adults, especially people with intellectual and developmental disabilities, folks start thinking about, can my person make decisions on his own? Do they need some level of support, or can they not make any decisions on their own? And do I need to go to court to take away their legal rights to do so? It's very hard for me to see questions in the chat as we go, but please put your questions in the chat and I will try and answer every single one of them when we get to the end of the presentation. So under Wisconsin law, these are things that are really bedrock that I want people to kind of needle into their minds. Under Wisconsin law, all adults, that means 18 and over in our state, have the capacity for decision making, unless somebody says, no, you don't. So we as a state presume that if you're 18, you can make decisions. We also know that decision making is a learned skill. And some of us who have been around longer than 18 years know that some of the decisions we made at 18, we would not make as we had more experience making decisions and we got older. So everybody has the ability to learn from their experiences and to grow and to make better decisions. Those are really core things that the law presumes about all people. You have the ability to make decisions. You learn from decisions, you learn from them. Doesn't mean you always make good ones, but you learn from them, and you need opportunity and experience to learn, to do that learning. Okay. I'm sorry about this. I have a mouse that is trigger happy. So why do we have a focus on decision making? Why is this a topic that we would be thinking about? You know, people, we in the disability field have this fancy term called self-determination. And what it means is, can you make choices about your own life for yourself? Do you get to choose something as simple as whether you want to leave and go and do something outside of your home and come back? Do you get to choose what you want to have for dinner this evening? Do you get to choose who your friends are and who you want to be around or live with, etc.? These are all examples of pretty basic, but also big choices that people like yourself, like me, can make all the time. And people who are able to make more choices and have more of a say in how their life looks and how and what they are doing tend to be healthier, more independent, more well-adjusted, and frankly safer. Because when you're making your own decisions about your own life, you are invested in doing whatever you're deciding. And most people choose to be more integrated and do more things. Most people want to have interactions with the community, with other people. And through those interactions, you learn things. And you learn what is normal, what is not normal. People who have more self-determination, the impact on their lives tends to be that they are more clear about what they want. And if something isn't right, that they are able to say, no, I don't want, that is not something that's okay. They're treated more fairly, they're more respected, they get choices about where and whom to live, and they choose their services. Oh no. I'm trying to get to the slide. There we are. We tend to spend a lot of time on this slide in this presentation. And this is important because I think for many people, especially with transition age youth, what they hear about is, oh, your child is 17 and a half, and that means they're almost 18. And when they turn 18, the law presumes they're an adult. There are lots of kids in high school, by the way, many of them who don't have disabilities, who turn 18 during their senior year. And it's no big deal. They turn 18 and most of them continue to do the same things they did when they were 17 and 364 days old. They keep going to school, they have attained adult status, but they keep doing the things that you would expect a senior in high school to do. And the schools don't make a big deal about the students who turn 18 who don't have a disability, because they just say, here's your book on what it means to be an adult. You're responsible for your own actions. Now you're 18. That whole idea of, okay, there's this magic number. And now that you're that magic number 18, we presume that you are capable of making your own decisions and you're allowed to do so. But that doesn't happen with students with disabilities a lot. And many parents hear, oh, your child is 17 and a half, you should go pursue guardianship, which is the purple column on this kind of continuum of decision making. It's the most restrictive and the most consequential thing that you can do to any human being when it comes to exercising their autonomy, their self-determination, their ability to make their own decisions. And you can see there are 4 other things here on this continuum. But for whatever reason, and if you're a student, especially one with intellectual and developmental disabilities, instead of presuming 18 means you're an adult and you are presumed competent under the law as it would for all people, parents often hear about, oh, you should get guardianship, and that may be all they hear about. So part of what we're doing today is talking about other things that you can do besides guardianship, and also some of the long-term impacts that if you do choose guardianship, you really need to think through. So the simplest thing, this is a continuum about how do you get help making decisions if you need help making decisions. I'm going to say everybody needs help making decisions, even those of us who think we're competent. We're not competent all the time, by the way, but we think we are. So, you know, some of these things are things that people without disabilities use too. And that's important to remember. Like, just because you need some support sometimes doesn't mean that you're not capable of legally making your own decisions. If you've ever been asked, say you've gone to a doctor and you've ever been asked to sign a release form so that somebody else could see your records, who maybe came with you, maybe they're related, maybe they're a friend, whatever, that person is providing a support for decisions for you, right? And release forms, we don't even think twice about them. Lots of different places use release forms. All they're saying to you is, are you giving me, the hospital, the bank, whomever it is, permission to share this data or this information about you with someone else? And sometimes they make you sign a release form every time. Sometimes they make you sign a release form and it's good in effect until you say no. But it's a really common thing that really is about, okay, who else can see your information? Doesn't impact whether or not you can make your own decisions at all, right? Moving to the yellow column, this is what we're primarily here to talk about tonight. Our state was one of the first states to, in 2018, pass legislation allowing supported decision-making agreements. Now there are 19 states in the country that have something similar in place called supported decision-making agreements. Each law, just like each guardianship law, varies from state to state. But the idea is the same, that it is a legal tool for the person, say me, say I'm the person, to choose who they would like to help them. The supporter, that's what we call them, a supporter, what they want help with, and what the parameters are for what that supporter can do. And we'll talk a lot about what is the role of a supporter, but the core thing here is, if you're a person using a supported decision-making agreement, you do not lose your legal rights to make your own decisions. You are the decider. The supporter isn't the decider. The supporter is there to support you. Much like many of us who have a friend group might consult people in our network about major life decisions, that's what this is about. You know, if I wanted, you know, to perhaps purchase a farm, that's a big idea, but I know Rose knows things about farming. Maybe I ask Rose about some things that I think she has expertise in. That is the same sort of idea, where you're asking people within your network to help you understand your choices, to help provide information, you know, to get information for you so you can make your own choices, to communicate that information for others. Supported decision-making is essentially what we all do all the time, anytime we're asking our friend group for advice. But for people with, you know, for people under this law, it's a actual formal agreement on paper that you can hand somebody and let them know why Rose is with me and what Rose is there for and what she is and isn't supposed to be doing with me, okay? In the blue column, representative payee. This is a little more restrictive, and this is only about Social Security benefits. So if you're a representative payee, that essentially means that you are the person that Social Security will send the check to, okay? So you're not the recipient, you're not the beneficiary of SSI or SSDI benefits. but you are the person designated to receive that money on their behalf. And that is more restrictive because the person themselves doesn't receive the money. So the payee is the person who has some amount of control over how those finances are distributed to the person and spent. In the red column here, we have, some of you may have heard of powers of attorney. Again, lots of states have their own statutes on powers of attorney. They're relatively new, to be honest, within like the last 30 or 40 years. And most of the time, powers of attorney are used for financial things or healthcare things. So you hear about a power of attorney for health care and a power of attorney for finances. Some states have a power of attorney for education. We really don't do that in Wisconsin. But the idea is that a power of attorney is you designated a person, a power of attorney, that's the title. Let's say Rose is my power of attorney. She's getting all sorts of authority this today. And that power of attorney can do certain things under certain conditions. So for example, it's a legal arrangement that lets Rose act on my behalf when I cannot do so on my own. And there's a lot of different ways to write a power of attorney. Most powers of attorney, again, are triggered with some series of events. So if you think about a healthcare power of attorney, I may be able to make all of my own healthcare decisions, but if I'm in a coma, then I'm probably not able to make my own healthcare decisions. And then the power of attorney is triggered probably for the length of time when I'm not able to make my own decisions. And when that power of attorney is triggered, Rose is the person responsible for making my medical decisions when I'm unable to do so. There are powers of attorney called durable powers of attorney that give the power of attorney a lot more leeway to act on somebody's behalf without necessarily consulting them at any time, but most are not designed that way. Sometimes when you have somebody who's, you got to really trust your durable power of attorney, it's a little more common with financial powers of attorney than medical powers of attorney, but there are lots of different ways that they can be triggered, that they can be written and triggered under different situations. And now we get to the purple column. Ooh, purple column. And now we're talking about either limited or full guardianship. And sometimes full guardianship is called plenary guardianship. Other states sometimes use the term conservatorship. Conservatorship and guardianship are really, you know, they're terms that mean the same thing, even though states have decided to use different words. They mean the same thing. And in guardianship, what you're doing is you're going to a court. You are petitioning the court to find the person that you want to get guardianship over legally incompetent to make their own decisions. And if the court finds that the person is legally incompetent to make their own decisions, what they do is strip that person of their civil legal rights to make their own decisions and transfer those rights to whomever the court decides they're going to appoint as a guardian. So the guardian, the person does not have rights to make their own decisions. It is the guardian that holds that deciding power. And the difference between a limited and a full guardianship is really a matter of degree. So you can have a limited guardianship where maybe the person retains, say, their right to vote or their right to marry or other things, but they don't retain their right to, say, control their own finances or, you know, make medical decisions or other things. I will tell you that in practice, many times people go to the court and they fill out the form, because you know how we all fill out forms. We kind of just fill out everything on the form. The form is actually asking you, do you want to keep or remove certain kinds of civil rights if you're petitioning for guardianship? And a lot of people just fill out the form and remove all their person's rights, and they don't even know it. Like including the right to own a firearm and to hunt and to get a fishing license and other things. So, you know, guardianship is really, it's really a very significant thing to do. And for lots of people with intellectual and developmental disabilities, this is the most restrictive thing that you can do to a person. You are taking away their rights to make decisions about their own lives. And it's permanent. Like you always have to go back to a court to try to get changes, and often they're not done. But it's where a lot of people start first. And what we're saying is there are other options that you can try before you get to a guardianship that often people don't know about. And supported decision-making is one, powers of attorney are another, and you can use something like supported decision-making agreements with powers of attorney. These things aren't mutually exclusive. But it's super hard once you're in a guardianship to make adjustments to it. And we're going to talk a little bit more about you know, some of the consequences to that. Okay, so why pause before considering guardianship? A lot of times families don't realize that once you're petitioning the court to be granted guardianship or to have a guardian appointed, that means the court is actually always the actor in charge of future decisions. So it's a big deal. There's a whole chapter of the statutes on what guardians can and cannot do. There's no training right now for guardians about what you're supposed to do as a guardian. You know, folks kind of get lulled into this sense of, oh, this is just an administrative thing. There's actually a whole bunch of responsibilities that come with it, including reporting to the court annually. And there's the courts are the ones that have oversight over guardianships to make sure that, in theory, that they're being conducted in a way that is in accordance with the state statutes, and that there isn't any overreach or abuse happening. We'll talk about how that isn't actually what happens in a little bit. The other thing that we talk about a lot is, you know, once the court has imposed a guardianship, they made a ruling that the person isn't competent to make their own decisions. And a lot of times they're relying on perhaps a medical record or maybe a diagnosis. You know, they have incomplete information. And for folks who are 17 and a half, when this happens to them, you know, a guardianship, at the point they're making a ruling on guardianship, it is a moment in time. And maybe there are some people at 17 and a half that have reached their full adulting and they have grown into the entire person they're ever going to be in their lives. But there are a lot of people where that isn't the case. That if you were to look at them at age 25, which is when neurologists say your brain is actually mature, or 35 or 45, they might be very different and have different capabilities than the moment in time when the guardianship was proposed. Once imposed, it is extraordinarily difficult, almost impossible, to get the guardianship reversed or even change the terms of the guardianship. It often takes a lot of legal representation because the court's already ruled that the person's incompetent. So you've kind of got to prove that they were incompetent before, but now they're competent. And that's a hard thing to prove. How would you prove that you're more competent now than you were 10 years ago? You gotta, I don't know how I do it. So it's a very consequential decision that is almost impossible to reverse. And of course, if you do end up wanting to say, I don't think I need a guardianship, I think I can manage with the power of attorney, you know, you've got to go back to the court. Most of the time, the person under guardianship is not the person who knows what their options are. It's not the person that has the money to go to court. They may have a guardian who doesn't really feel like they don't need to be a guardian anymore. I've had guardians who have wanted to not be the guardian anymore because they think the person is competent, who have had a real tough time. So even when you have the will of the person and the will of the guardian, the money to go back to court and the will to go through that process, it doesn't happen. The other thing that folks sometimes think is that the guardianship order provides some sort of protection. It's a piece of paper. Your person isn't necessarily any safer because that paper exists than if they didn't have it. And I will tell you that lots of times the prejudice against people with disabilities is such that providers and others look to somebody who looks like they don't have a disability and may assume that that person's the guardian, or ask, are you the guardian? And if Rose went with me to the hospital and Rose said that she was my guardian, very few people would necessarily question that. Almost none of them would ask to see the order, and almost none of them would look at that order to see what authority Rose has to make decisions on my life. And I'm not picking on doctors here, because that's true with other providers too. And that means that the deference to guardians lends them to overreaching beyond what the statutes allow them to do sometimes. And once somebody is under guardianship, they know it. They know that they don't have the ability to control certain or all aspects of their life. And you as we've said, if you don't practice decision making, you don't get better at it. So there's kind of a learned helplessness is the term, but there's often, people who are under guardianship, they do know that they're right, that they do not have rights to make certain decisions. And as we've talked about self-determination before, that sometimes can make them less safe because they don't know when something isn't normal and they're used to having somebody make decisions about them for them. We've talked about how sometimes people don't know what rights they're taking away, that there isn't really a good training program at this point to help guardians do their jobs the best that they can and at least know what the requirements are. Again, the court being the decider is important because you may have a plan as to how you want this to work out, right? You may say, okay, I'm petitioning for guardianship and I am going to do a limited guardianship and these are the rights that I want that my board to retain, and this is the part that I'm willing to take on. Once you put it in front of the court makes the decisions. So sometimes the court says, yeah, I don't think you're the person I want to be the guardian. I'm appointing somebody else. Or, yeah, I see that you've petitioned for a limited guardianship. We only do full guardianships here. So you don't have control of that deciding process. And I think a lot of families are surprised by that. There's also, again, as people age, if you're the guardian, there isn't that you can say, here's who I would like to be the successor guardian, but it is the court that makes the final decision on whether or not the person you think you've chosen to take on those responsibilities for you can't anymore, or you have passed on, or whatever it is. The court's always going to be making the decision on who's the next guardian. And for a lot of aging parents who may have had a plan in place and that plan has changed for whatever reason, you might end up having your person be appointed a corporate guardian who may have many people that they are a guardian of. And lots of folks sometimes don't see that. This is just a little graph from current data that says, hey, you know, if you have a guardianship, how many people feel like they have those choices in their lives, right? And you can see that there's an awful lot of people that say, no, that's not true for me. So now we're going to change to Wisconsin supported decision-making law, which is an alternative to guardianship, and talk about what it is and how it works. Like I said, 19 states have now passed some form of this law. This is all about Wisconsin supported decision-making law. Again, based on the principles that we discussed at the beginning of this presentation, everybody can make choices. You can ask for help without giving up your rights to make choices. And people often need help in understanding, making, and communicating their choices. So what is a supported decision-making agreement designed to do? Really a document that helps the person communicate and interact with third parties. Third parties meaning maybe a state agency, maybe a bank or a healthcare agency or some other business service provider. It lets that third party know, oh, you have a supported decision-making agreement. Ding, ding, you are the person in charge. This is your supporter. This is what your supporter's here for, and this is what your supporter's role is. That's what a supported decision-making agreement allows people to do. In Wisconsin, we have a definition within the statute that defines who can use a supported decision-making agreement. It's not everybody, but it's a lot of them. And interestingly enough, every state, we were the fourth state to pass a supported decision-making law. Every state after us has copied some parts of our law, which I'm very pleased about. In fact, some of the states that copied some of our law actually decided that they didn't need to restrict who could make a supported decision-making agreement at all. So in some places, anybody can use a supported decision-making agreement. In Wisconsin, we narrow that a little bit. The definition that's used is anybody with a functional impairment. And no, you don't need to have any medical proof that you have a functional impairment. You're self-deciding whether or not you're a person that has a degenerative disease or a condition that substantially interferes with the ability to do daily living, major life activities, or self-care tasks. People with intellectual developmental disabilities are included in that definition. People with a primary diagnosis of mental health, and people with physical disabilities. So if you have a disability, yeah, you can use this. If you're an older adult, you probably can use this. And if you're not that old, but you have a chronic condition or a degenerative disease or have something that limits your ability to be fully self-sufficient in self-care or major life activities, yes, you can use this. We're very deliberate to not put in an age because things happen to people all the time at all sorts of ages. So if you have multiple sclerosis and you're in your 40s, you should be allowed to use this even though you're not particularly old. That's why this definition is as it is, because it's trying to be as expansive to people as possible. You can use these agreements for any type of decision that you deem fit. There is a form that's actually set out in the statute, and the form includes various things you can choose from. But there's also space for other. So if you need help deciding who's the right roofing company for my roof, or who should I use to prepare my taxes, or replace an air conditioner, or, you know, how do I figure out a phone plan? You can use a supported decision-making for that. Supported decision-making agreements are meant to be flexible and updated very easily as somebody's ability to make decisions changes, either increases or decreases. And this is not true of a power of attorney, right? Powers of attorney are primarily about finances and medical care. Supported decision-making agreements cover everything else. Could cover medical or financial things too, but there wasn't a tool before supported decision-making that really allowed some support for somebody who's making one of the 1,001 other decisions in life that are actually important, that you might want help with. Okay, this is super important. What do supported decision-makings not do? They don't restrict a person's right to make the decision. The person who is writing the agreement is always the decider. They're always in control of their own decisions. The supporter of that person doesn't gain any new rights. The supporter is there for a very defined role. They don't get to sign contracts on behalf of people. They don't have any authority to make that person's decisions for them. They are there to support that person in the way the person wants to be supported. The supported decision-making agreement puts the person who needs the help in the center and control of defining who and how they want that help. So what do you do if you're a supporter? All right, Rose, you're going to be my supporter. Well, it's really limited under our law to 4 distinct things that I can ask Rose to do for me. I can ask her to get information relevant to my decision area. In other words, Rose doesn't, if I say, Rose, I need your help getting information, that doesn't mean Rose could like download everything there is about me and she gets to like know my taxes and my Facebook feed and all that stuff. But she does get to be able to request information that is relevant to the decision area that I'm talking about. Let's say Rose is helping me with my phone plan, right? So maybe she'd want, maybe I'm saying, Rose, I need help accessing my online billing. I can't figure that out. Lots of people have trouble accessing technology. Think about a blind person and how many websites are completely inaccessible for folks with sensory disabilities. That's a perfectly fine thing to have a supported decision-making agreement on, and you're just helping get them the information they need to make a decision. You might be asked to sign a release form, you know, that it doesn't mean the person who has the information doesn't have you sign that. That's fine. But it does mean that, you know, the person is able to have somebody else gather information for them on that decision. So if we're doing a phone plan, maybe it's the billing, maybe it's also comparing different, you know, looking at 3 or 4 different companies and pulling their offers together in one place. That's a lot of work, actually, and it's hard for a lot of people. So it's a really valuable thing. The second thing Rose might be able to do for me is helping me understand the information she's pulled. What does it mean? Can you read it to me? Can you put it into simple words? Can you translate that for me in a way that makes sense to me? She might also help me understand my options. And that can include, okay, if you choose option A, what are you responsible for? What are some of the pros and cons? Just like you would do with any friend, right? You say, well, there's this option, and this option. And I think this one has these advantages and disadvantages. That's the kind of thing. You're not making a decision on behalf of the person, but you're helping them understand what their options are, so they can make their own informed position. And the fourth piece is assisting with communicating the person's decisions to others. I actually was the primary person who worked on passing this law. And I will tell you that I underestimated how important that fourth thing was. I thought, well, yeah, that makes sense. We should include that. But I didn't realize exactly how many people, that's all they want. A lot of the folks that I know who have cerebral palsy, for example, where there might be or even autism, where there's nonverbal autism, a lot of those folks, it isn't so much that they don't know exactly what they want and can make decisions, but it's that other people can't understand what those decisions are. So I vastly underestimated the importance of having a person, let's say Rose, who understands how I communicate and is able to kind of play that translation role for me. So if I'm a person with cerebral palsy, where the cerebral palsy has created an impediment, a speech impediment that lots of people aren't familiar with. Any non-traditional communication style that isn't, talking, this is a really important thing for them. So how do we use these supported decision-making agreements? I've already said that the form is actually in the statutes, and we have a link to the form in this presentation. There are several things that are kind of check mark yes, no's on the form already. And it's really the first 6 bullets here. That's part of the standard form. The reason that supported decision-making is so flexible is this last bullet, which says other decisions, and has a blank line for you to write stuff down. That essentially means that the supported decision-making agreement is as flexible as the ideas that the person has for the decisions they need help with. There are lots of folks that would want help on one of the 6 things that are on the form, but this other piece is really what makes it customizable to the unique needs of the person. It's presumed under the law that if you don't check yes, you're not giving permission. So, if you're the person who's filling out the form, it's your agreement. If the box is unchecked, the law presumes that you're not giving the supporter the ability to help you with that kind of decision. I apologize, this is really irritating. So here is the link for where the official form for the state sits. It's housed on the DHS website. Supported decision-making does not require you to have a lawyer. Powers of attorney don't either, but many people choose to go to a power of attorney to have one drawn up because there are so many ways that you can draw a power of attorney up. This is really designed to be something that you yourself can do and that you yourself can change. All right, some other things about supported decision-making. So when do these agreements end? When do they start? It's up to you. We have a whole supported decision-making toolkit that our board has put together with some advice about how you revisit your supported decision-making agreement and make sure that you have a conversation with the supporter you've chosen periodically to see if you need to make any changes. But again, the power of the supported decision-making agreement is you can say this agreement is in effect until we decide not to, and it's not in effect, and either the supporter or the person can say, okay, I can't, I don't need you as a supporter anymore, or supporter, I can't fulfill that role for you anymore. You can specify a date when the agreement ends. And of course, if you're an abusive supporter, the law does say there are terms where it's automatically revoked. We won't spend a lot of time on that, but that is part of the law. Yes, you can have multiple supported decision-making agreements. Just like when you think about your friend network, there are some people who you would ask for advice on different things. I wouldn't ask the same person in my life for advice on what kind of computer system do I need as I do for what kind of tires do I need for my car. I have different people in my life who have more or less expertise on various topics, just like you and I have things we know more or less about. So yeah, you can have multiple supported decision-making agreements and multiple supporters. And you can make those agreements very narrow, that you're only choosing a supporter to help you with a very specific thing. Or you can have one supporter that you really go to for lots of things. That's okay too. You can also, in terms of customizable, you know, if I choose Rose as my supporter and I say, Rose, I want your help with how to do a phone plan, I don't have to give Rose all 4 of the possible roles that she could have. Maybe my only thing I want Rose to do is help me gather information about phone plans. Or I could have her do a little more information and help me understand what my options are. Or maybe I give her 3 things: information, help me understand my options. Or I could do everything. Phone plans, help me get the information, help me understand my options, and help me communicate. You can, you know, give your supporter more or less of a role. There are liability protections in the law, mostly so that the person who's receiving the agreement knows that they can rely on that as a legally valid representation of the person's wishes. Anybody who suspects abuse, that the supporter is abusing the person that they're supposed to support, just like you would report anybody else you suspect of abuse or neglect, whether it's a power of attorney or a guardian or a service provider or just Joe Schmo off the street. If you're not a mandatory reporter, you can report that person to law enforcement or adult protective services. And if you are a mandatory reporter, the law already requires you to report abuse, neglect, or financial exploitation to law enforcement or adult protective services. So that doesn't change for you. A few resources. Like I said, we have a toolkit, and I will put that after the presentation in the chat for you. It's designed to be really for families and individuals who might want an agreement. All right, practical examples. We're going to fly through this and then we'll have time for questions. So, why would you want to use a supported decision-making agreement? My friend Janet works more with the aging advocacy side, and you know, she will often say there are a lot of things that people don't anticipate that become true. Sometimes the people who know you the best and who you would turn to on certain issues or just are involved in your daily life aren't family. Sometimes they're extended family. So they wouldn't, you know, maybe it isn't a husband or a child, but maybe it's your Aunt Tilly, for example, who is a person that isn't necessarily, you know, is part of your extended family, but not you're as closely related as some others. Lots of times families can be small, they can be geographically dispersed. There are people who never had families or people whose family members are no longer with them unexpectedly. Supported decision-making agreements ensure that folks who aren't family or who are extended family are recognized, that they have a role under the agreement and what that role is. And that the person has said, yes, I want this person who isn't my son or my daughter or whomever to be with me to do these things. It's really important, especially as we are an aging state and that families are smaller and that people tend to live in different places. And geographically close, Wisconsin's a big state. Like I live in Verona, it's 6 hours to Superior. So you could be in the same state and it's still kind of far away. And even if you're, you know that person in Superior and you interact with them routinely, it might not be the same as seeing them every day, right? So this recognizes that there is an extended network of people in people's lives that can play a role in helping them, supporting them in making decisions and staying in them. Important here, a supported decision-making agreement can flex. Unlike a guardianship that is imposed at one point in time and the terms of the guardianship are fixed, a supported decision-making agreement is really easy to change. So if you have one at age 18 and you get more practice making decisions and you get better at it, maybe your supported decision-making agreement shrinks or goes away in certain areas of your life because you don't need the same level of support anymore. Similarly, sometimes people end up needing more support as they age or a disability changes. A supporting decision-making agreement can change with you. We have a picture here of an older couple. There are lots of folks who have a little dementia they need a little help for a long time. Dementia is a great example of that. If you're an age 70 and you're diagnosed with dementia and you can make your own decisions until 90, why put 20 years of guardianship on that person when you can have a supported decision-making agreement that evolves and grows with you until maybe that isn't enough, right? You can always do the more restrictive things later on. We've talked about this already, but I'll just say it again. Supported decision-making can be used for lots of kinds of decisions that a power of attorney doesn't cover. That's useful. Oftentimes, people are wrongly told, this is actually not what the federal law says, but they're told, oh, well, if you turn 18, you can't come, if your person turns 18, you can't come to the IEP meeting unless you're the guardian. Absolutely false, friends. All the student has to do is say, yeah, I want my mom to come to the IEP meeting. She doesn't have to be a guardian. She just has to be allowed to be there by the student. But, if you have a school district or another agency that's a little bit nervous, oh, you're not the guardian, can you be there? Yeah, supported decision-making agreement is a way to formally say, yeah, I want my mom to be there, okay? We've talked about this a little bit. The communication role that supported decision-making agreements can give supporters is hugely helpful, not only to the person, but to professionals. Some of you who, I assume maybe have children with disabilities, what your kid is saying in a way that perhaps a doctor that's never met them before will not be able to understand, right? So that ability to make sure that the person is clearly being understood by a third party is really, really important, as is the ability for the practitioner to be clearly heard by the person. I don't know if any of you have been in a medical appointment where you're sitting around waiting and somebody comes in and they start talking and the doctor talks for 5 minutes and you get to the end of it and you're like, okay, I lost you on acronym 4. And you have to sit there and go, I heard the words that he was saying, or she, and I did not understand any of them. And then you have to kind of parrot it back and forth, right? Well, the other piece is not only are people who are talking fast and who are experts in their own field sometimes unclear to those of us who are not, who are not at the same expertise level, but they are often communicating information that might be emotionally hard or startling. And a supporter can do a lot of work to make sure they're translating slowing down and translating what the professional is saying into terms and words and things that the person understands, kind of a reverse translation. And it's critically important because, if you got 5 minutes with the doctor and you don't interrupt them or you don't ask questions, I know that I never understand what's going on. It's also a really good, you know, a lot of times people with disabilities are, there is an inherent bias that I think we need to admit. Under law, everybody's presumed to be competent. Why is it that we presume the opposite for people with disabilities? Because we have a bias that says, well, these people actually aren't to be presumed competent. It's the wrong way of thinking under the law, but lots of times it happens. And supported decision-making is a way for that person to say, no, here's the paper. I'm in charge. I'm going to challenge your assumptions that I can't make my own decisions. I'm going to challenge you to be somebody who's going to explain to me in a way I understand what my options are. And I have this person here with me to help you do that. It very much orients the professionals to the person, which is where they should be oriented all the way. So that is the end of my presentation, and I've gone a minute over, and we've lost the person. So if there's any questions, I'm happy to answer it. Otherwise, I'll talk about the Senate Judiciary hearing that was held a couple weeks ago, because I know Tim wanted to hear about that.
Okay, I'm wondering, Tami, Tim, or Hunter, you guys tell me, Tom, you tell me, should I stop the recording at this point since we're going to share it out with people that weren't here?
Fine with me.
Okay.